I'm Pat Torres. Welcome to The Story. When Oregon's gun control law, called Measure 114, was narrowly passed by voters just over a year ago, the Story team here at KGW looked at each other and said, this is a law we're going to be covering for a long time because it's going to be tested in the courts for months, potentially years to come. So far, we've been right. Late yesterday, a big win for pro-gun folks. An Eastern Oregon judge ruled against Measure 114, and that is our big story tonight. Here's the ruling from Harney County Circuit Court Judge Robert Rascio. He's been responsible for pausing 114 over the last year, placing a temporary injunction on the law in December of 2022. That was ahead of a 6-day trial that took place just 2 months ago. And then yesterday's ruling is a result of that trial. Plaintiffs argued the Measure 114 violates Oregon's Constitution, and Rascio agreed. He placed a permanent injunction on 114. That means the law cannot take effect unless a higher state court overturns his decision. The state attorney general's office will now try to make that happen as soon as possible. There's been some confusion over the lawsuit involving Measure 114, and it's important to note that we're talking tonight about the state case. A federal suit is also playing out in federal court with very different results. There, a federal judge already ruled that 114 is constitutional when it relates to the U.S. Constitution. That federal case is now being appealed and could make its way all the way to the U.S. Supreme Court. Could. We'll see. The state case rests on the Oregon Constitution. So even though a federal judge has said all's well here, that ruling does not override the state case because they involve different constitutions. Now that we've got that out of the way, let's do a brief recap on what Measure 114 would do. Its two big requirements are a permit to purchase regulation and banning magazines that hold more than 10 rounds of ammo. That permit program would require anyone who wants to buy a gun to take a safety course and then go through a criminal background check. In his ruling, Judge Rascio said all of that unconstitutional. Now, before we dive into parts of the judge's opinion, a disclaimer here. It's 44 pages long, so there's no way we can go through every argument for you tonight. But there are a few that we're going to highlight. The judge wrote, Oregon citizens have a right to self-defense against an imminent threat of harm, which is unduly burdened by ballot measure 114. He said the state attorneys failed to prove that either part of Measure 114 would promote public safety. When it comes to the permit to purchase regulation, Measure 114 gives sheriff's offices a 30-day window to process the gun permit applications. And Rascio said that potential delay of 30 days restricts the rights of Oregonians to defend themselves from an imminent threat. Now, when it comes to banning magazines that hold more than 10 rounds, the state argued it would reduce fatalities and mass shootings because a shooter would have to pause to reload, giving people time to escape. Judge Rascio was not buying that one either. He wrote, a motivated mass shooter could carry well over 100 rounds in 10 separate magazines and readily release a detachable magazine from a firearm and reload in 2 seconds, offering none of the supposed protection promoted in the preamble or voter's guide for ballot measure 114. Now, the big difference between this ruling and previous federal rulings is that Judge Rascio says ammo magazines are considered protected firearms, while the federal judge said, no, they're not. Rascio found that guns like the Colt revolver and multi-barrel firearms in the early 1800s were examples of large magazines used for self-defense when Oregon's Constitution was ratified back in the late 1850s. That goes against what state experts claimed at trial, saying that those guns that could fire multiple rounds were extremely uncommon and vanishingly rare in Oregon at that time. Finally, there's one last point in the judge's opinion that I really want to address. Referring to mass shootings, the judge wrote that people tend to believe they happen all the time and said that belief is sensationalized by the media. He wrote that they rank very low in frequency. But this sentence really stood out to me. The court finds the number of people killed and injured is statically insignificant compared to the number of lawful gun owners. You heard that right, statically, not statistically, as in not changing. Now, I don't know if he meant statistically, and the word is just a typo, but frankly, it doesn't matter. Here's my opinion on all this. First, you should know that I am a gun owner. I grew up hunting. I think that shooting targets at a gun range or hunting, frankly, is a lot of fun. But that last comment from the judge about the number of people killed and injured, that does bother me. I went to everytownresearch.org, and they are an anti-gun group with something like 10 million followers. So yes, they're very biased, but they track these things, and I do trust their numbers. They report there were 636 mass shootings in America in 2022. A mass shooting, by their definition, is 4 or more people shot, not including the shooter. In those 636 mass shootings, 600 people were killed, another 2,700 wounded. And that's just last year, in 1 year in America. Now, according to Pew Research, there are roughly 83 million people in the U.S. who owns guns. So, yes, I guess you could argue in a vacuum that the number of mass shootings versus the number of gun owners in America is indeed small. But that totally ignores the consequences. Think of it like this. The number of bombs that go off in airliners is a small number compared to the number of planes that fly every day. Does that mean we should take down metal detectors and skip security at the airport? Of course not. Every one is too important. Even one explosion is one too many. Although I do think that taking off my shoes at the metal detector is a little much, but that's for a different day. The point is, the consequences are huge. We don't want bombs on planes ever. It should be the same for mass shootings. For every single person hurt or killed in one of these things, there are significant shockwaves of grief and horror that ripple out across the country. So come on. In my opinion, that is a ridiculous argument to make, Judge. The judge also says high-capacity magazine ban is meaningless because a shooter could just eject one clip and reload in a second clip in a couple of seconds. Really? I mean, maybe that happens in a video game, maybe. But in the real world, anything can happen. As they try to reload, the shooter could fumble the next clip. Someone could tackle them. Things happen. And anything that makes a mass shooting harder should be considered, in my opinion. Let's think about it in terms of suicides. There's a lot of research showing that even a single barrier stops many suicides. Things like fences on the side of bridges. It delays the impulse and the terrible action. The judge wrote, well, a motivated shooter could quickly reload during a shooting event, even if they were limited to 10 bullets in a clip. Well, Judge, a motivated shooter could also go to the black market and buy an illegal gun with a huge clip of bullets and not have to worry about reloading at all. In my opinion, it's not about how motivated they are. It's about how many barriers are in the way of someone who's on the edge of doing something awful like this, whether to do the shooting or not, whether to continue shooting or not. Now, I know that folks in rural parts of Oregon think this law is just nuts and created by the city folks, and it was created and passed by city folks. There are many parts of our state where it does make sense to arm yourself to protect yourself because the police are not going to get to your place in time. But the state constitution says we have the right to bear arms for defense of ourselves. It's about defense, not offense. It's about having a shield, not a sword. I think the judge is stretching way too far to rule this law unconstitutional. Yes, it does have problems, for sure. But in my opinion, not constitutional problems and not the problems we've been talking about here. That's my opinion anyway, and I'm not a lawyer. I could be full of it. I'm often told that by people. And you don't have to agree, but it would be great if you did communicate. So, what do you think? Email me, will you? The address is thestory@kgw.com or call and leave a voicemail. The number is 503-226-5090. I look forward to hearing from you. Last week, we took a deep dive into tainted groundwater in eastern Oregon and the state's stunning lack of action towards stopping the pollution. Tonight, we're going to talk more about groundwater. And if you live outside of Oregon, hold on, stay with us. It still applies to you. Groundwater is the stuff that's underground, everything besides oceans and lakes and rivers. People with wells tap into that groundwater. And in many parts of Oregon, the groundwater is polluted. It's contaminated. It's not safe to drink. The tricky thing is, if you drink from a well that taps into a relatively young aquifer, that's what the water under the ground is called, it may taste great, even though it's contaminated. I'm telling you that because I got an email last week after our reports from someone who used to be inside the Oregon Department of Environmental Quality, and he's still very concerned about groundwater. He thinks thousands of you who use wells are drinking polluted water and don't know it. Greg Pettit is the person who sent me that email. He's retired now, but he worked nearly 4 decades for the Oregon DEQ. His job included manager of the water quality monitoring section and later administrator of the Laboratory Environmental Assessment Division.
I think that the awareness of the problem is very limited, and that's part of the problem. People simply not aware that this is a problem.
Is that why you're stepping forward?
Well, it's been a passion of mine ever since I found contamination back in the mid-80s, that it's just not getting the attention it deserves to protect people's health. And so I'm always willing to step up and say what I know about the issue. Probably nobody in the state has a longer history with this problem that's around than I do right now, so hopefully we don't have to repeat lessons that were learned years ago.
Pettit there is arguably the guy responsible for Oregon's Groundwater Quality Protection Act, which passed back in 1989. In 1985, he applied for an EPA grant and used the money to test private wells across Oregon.
So when we did the initial survey in 1985, we sampled 380 wells statewide, and we found extensive contamination well, the worst areas we found were in the lower Umatilla Basin, which you've done the story about, in the Malheur Basin around Ontario, and in the Willamette Valley.
He said there was other parts of the state that were contaminated as well. And the new state law grew from that. It requires the state to protect groundwater, and when contamination is found, the law requires the state to put rules in place to clean it up. But as we saw in the lower Umatilla Basin, that is not happening. The reason, according to Pettit, politics. Most of the pollution comes from the farming industry, and they are very good at pushing back.
The political pressure of the ag lobby in this state and the lack of very specific regulatory drivers to do something, between those two things, nobody's been willing to stick their neck out there and take that issue on directly. And I know that I worked a little bit with Leah Feldon, the new director at the DEQ laboratory, and I know she is very concerned about environmental justice issues. And this groundwater contamination problem, to me, is the most documentable environmental justice issues in the state. Because for the most part, people that are being exposed to these contaminants in their groundwater are people that don't have power. They have a limited voice in the community. And even within their communities that are dominated by agricultural industry, it's not a comfortable position to get out and start complaining about agriculture. You know, you can see the position it puts in them. So there's very little, for the people that are being affected, there's a lot of things that make it very hard for them to get the problem changed.
By the way, he meant to say that Leah Feldon is the director of the DEQ, which she now is. So the people most impacted have little political power, and the farm lobby is very powerful and very good at pushing back politically. On top of that, he said there are no specific laws that focus on testing wells after they're put in place. Again, that means if you drink well water anywhere in Oregon, you may have contaminated water and you just don't realize it.
There are about at least 700,000 people in Oregon who get their water from private wells. And there is no program currently in place to ensure that those people are not being exposed to contaminants that could endanger their health.
There's no regulations?
There's no regulations. The Safe Drinking Water Act, which is a federal act, only covers public water supplies. And so these private well owners are mainly on their own. Now, DEQ and Oregon Health Authority, they recommend it, and if you go to their website, they'll say you should have your well tested, and these are the things you should have it tested for and whatnot. But based upon your story and based upon my experience, especially when you get outside Lub, which is at lower Umatilla Basin, which is an area where the groundwater problems are fairly well known, but you get in other areas of the state, and people think if this water tastes and looks, it smells great, it's good water. So I'm sure that there are thousands, probably tens of thousands of people in this state drinking water from wells that have contaminants in them.
I think that's a stunning thing to say. But he said it has not been a primary concern or a priority at the DEQ. Instead, through the years, Pettit says DEQ moved money away from groundwater issues. It lost its urgency in a blizzard of other priorities and federal programs that the DEQ carries out or monitors. Now, he said, it is time to return to a focus to groundwater and all those people drinking from wells statewide. And he says the way to protect it, mandatory rules to restrict farmers and others from polluting the aquifer below the ground.
You know, I'm just being perfectly honest with you here, Pat. If you look at the great environmental improvements in water quality, in air quality, in reducing hazardous waste sites around the state, in the nation. There's tons of data. I have a PowerPoint presentation I could show you. There's tons of data that shows that specific regulatory programs, when implemented, made drastic improvements in our environmental quality. We certainly want to encourage voluntary efforts to improve the environment. But if you look at what has worked historically for the last 50 years, when there have been major new requirements through one of these federal acts implemented, we can measure fairly drastic improvements in air and water quality. And I'm talking about like 1/10 the contamination that was there before.
And when you say major new requirements, you mean mandatory?
I mean mandatory, exactly. I'm talking about mandatory. These programs, the federal acts, were pretty much all mandatory when they were enacted.
By the way, we've asked for interviews with the regional director of the EPA and also the state director of the DEQ. We look forward to bringing those to you one of these days soon. So he's saying there that there should be mandatory new rules that limit the contamination of groundwater and protect the 700,000 people drinking well water in Oregon. We're going to be exploring this issue quite a bit in the coming year. In the meantime, I hope you'll take a few moments to watch our series of reports from Eastern Oregon. It's called Tainted Waters. It's posted now on our KGW YouTube channel. We also have a documentary version of the report, which you can also find on our YouTube channel or our streaming app on Roku and Amazon Fire. It's called KGW Plus. In the meantime, up next on the story, KGW's investigative documentary Sick Medicine took a close look at doctors accused or disciplined for serious misconduct who were then allowed to keep practicing medicine. Through the course of that work, the Oregon Medical Board sued us to keep us from getting documents about a doctor accused of sexual battery. The judge ruled on that lawsuit late yesterday. We'll explain how it went when the story returns. Now to a follow-up on KGW's investigative documentary, Sick Medicine. Our team spent 9 months researching doctors accused or disciplined for serious misconduct who were then allowed to keep practicing medicine. But amid that investigation, a legal battle between KGW and the Oregon Medical Board began. Our team has been trying to obtain records about a doctor accused of sexual battery, but the medical board sued KGW to keep those documents private. Well, late yesterday, a Multnomah County judge ruled in favor of KGW for the most part and said the medical board should turn over some of the records we're seeking. Ashley Korsland explains.
For months, KGW has worked to get public records related to the Oregon Medical Board's investigation into Dr. Christopher Baldwin, an internal medicine physician who used to work in Oregon and now holds a medical license in Arizona. Dr. Baldwin's case was featured in Sick Medicine, KGW's new investigative documentary. We found dozens of cases where doctors accused of serious misconduct in Oregon were allowed to keep practicing, oftentimes in different states.
In the case of Oregon Medical Board versus King Broadcasting Company et al., case number 23.
On Tuesday, a Multnomah County judge ruled partially in KGW's favor to obtain public records about Dr. Baldwin, saying the Oregon Medical Board must turn over documents related to the advice the board gave to Dr. Baldwin following its investigation into his alleged sexual misconduct. In 2020, 8 women sued Dr. Baldwin, accusing him of sexual battery and medical negligence. The women accused Baldwin of pulling back their shirts and staring at their breasts in a way that wasn't medically necessary. 3 of the women additionally accused him of inappropriately touching their breasts or genital areas. The lawsuit triggered an investigation by the Oregon Medical Board. The board has not disclosed the outcome of the investigation, although Dr. Baldwin was never publicly sanctioned. He was, however, issued a letter of concern, which the medical board has so far refused to make public. After the board's investigation, Dr. Baldwin's medical license in Oregon was placed on inactive status. Later that same year, in September of 2022, records show Baldwin obtained a medical license in Arizona. A search for his new medical license in Arizona showed no indication of the past investigation in Oregon. KGW has tried to obtain the letter of concern issued to Dr. Baldwin, but the Oregon Medical Board has repeatedly argued the letter is confidential. KGW even appealed to the Oregon Attorney General's office, which agreed the letter of concern is indeed a public record. It ordered the medical board to turn it over. Instead, the board sued KGW, asking a state judge to rule the letter of concern should remain private. On Tuesday, attorneys for KGW and the medical board argued their points during a virtual hearing in Multnomah County Court.
The publicly available information in this case that the defendants have introduced strongly indicates that Dr. Baldwin may present a significant threat to public safety.
What we're dealing with here is something very different, which is simply a generalized articulation of a public interest that is nothing more than the desire to know what happened and how the medical board made its decision.
Because
Judge Leslie Roberts acknowledged that portions of the records KGW are seeking may be confidential under Oregon law, but she ordered the Oregon Medical Board to disclose documents containing advice or guidance that the board issued to Dr. Baldwin. Judge Roberts denied a motion from the medical board to keep all records confidential.
I would grant defendant's motion only in part and only as to statements or portions of statements that do not contain information derived from the investigation, and would otherwise deny that motion. And I will deny the plaintiff's motion in its totality.
This ruling means KGW can now obtain at least parts of the letter of concern, although the Oregon Medical Board has the right to appeal. Ashley Korsland, KGW News.
Thanks, Ashley. Our team gave the Oregon Medical Board several chances to do interviews about this, but they've refused. The agency did email us a statement saying that the board stands by the way it disciplines doctors and that it has a zero-tolerance culture for sexual misconduct. If you'd like to watch KGW's investigative documentary, Sick Medicine, it's available right now on the KGW YouTube page and on our streaming service, KGW+. Stay with us. We're back right after this. Well, that's the end of our show. Thanks so much for watching. And remember, the story, our collective story, well, that never ends. Hey, because of the Thanksgiving holiday tomorrow and then college football on Friday, we're not going to have any shows for you the rest of the week. And then I'm taking some time off that next week. But investigative reporter Evan Watson will be right here filling in. And holy smokes, does he have some great stories to bring you. Enjoy your Thanksgiving. I hope you'll tune in on Monday at 6:30.